Chair calls Carl Hayes.
Mr. Chairman, I'm not going to testify. Just mark me down as opposed to 3440.
All right. Well, thank you a lot. Well, then we call Steve Bresnan. Now you you didn't talk to him back there, Carl? Give us your name, who you represent, and your positions on, looks like 2157 3414.
Mr. Chairman, my name is Steve Bresnan. I'm here for House Bill 1807 and against 2157 and 3414 on behalf of the Texas Family Law Foundation. First, I want to thank Reverend Sanford and Representative Middleton. We've had some very thoughtful discussions about these issues this session and in previous sessions. And I also think it's fair to demonstrate that we fully respect the degree of emotion and heartfelt sincerity from the witnesses that have preceded me. For every one of those individual situations, there's a story, and if we could get into them, we could probably see what went wrong. Bad facts, bad judges, bad lawyers, any number of things. For every one of the situations that people have testified that they're unhappy with the result, there's somebody on the other side of that equation who was happy or satisfied with it. And so those people don't tend to come out to these hearings. I want to just clear a couple of things up. I'm handing you a schedule. If a person elects all of the rights that they have, all the options that they have under 153.317 of the Family Code, this is what they would get. In 1 year, 2018 is demonstrated, 2019 is demonstrated. The yellow pieces are overnights. The green pieces are the times when the kid woke up at that non-custodial parent's home, and they got them, presumably, they fed them, got them clothed, got their school books, got them off to school. You can look at the bottom on each one, 138 overnights in 2019, 43 of the other days, comes out to almost exactly 50%. In 1807, if you'll look, we've reorganized the statute to make it absolutely clear that people have a right to increase their time by exercising the options that are in the law.
Okay, Mr. President, appreciate you for being here. Question for Mr. Bresnan. Representative Callahan.
I just want to say what you just kind of rephrase what you said. You said that in all of these cases that we could probably look at them and see what happened, and that there
Sure.
would be bad judges and bad lawyers in some of them as to why the outcomes came about. And I think that that's a really good point, bad judges and bad lawyers, but that's why we need good laws in order to protect parents and children in the state of Texas.
May I flesh that out a little bit?
Sure.
Okay, good. You'll really appreciate the members taking this level of interest and paying attention. There are also bad facts. There are reasons that courts don't allocate as much time. They could be reasons because the needs of the child or the inability of the parents to cooperate with each other. Because someone might not exercise a given option in 317 because they work at a time where they can't be back and pick up that child at 4 o'clock or whenever school comes out. My point is, this law allocates the time in a way that is fair, and it encourages maximizing time. Where that doesn't happen, there are an innumerable number of reasons. And let me give you one good example. Many people come through the child support system. I want to be clear, I'm not faulting the Attorney General or the child support system, but they're dealing with very difficult situations where they're trying to get support for that child paid to somebody. Many times paternity has not been established. So they establish it along the way, and then that one of those parents has got an option to exercise. Many times they're exercising the basic possession order. The gentleman talked about, it says the standard possession order is the minimum reasonable time. If you read it, it says under subchapter F. the options under 317 are under subchapter F. So you guys are talking about making laws. First thing you got to do is understand those laws and exactly what they say. People that are coming through that system, there are hundreds of thousands of people that are making elections. Many of them are young people. Many of them never had anything to do with the mother of the child. And so they're going through a process they don't understand. They're oftentimes not represented by counsel. It's probably beyond the ability of the Attorney General's office to advise everyone about what their options in full, and that's a practical matter that needs to be addressed. Costs of the court system, those are practical matters that need to be addressed. 70% of family lawyers, of the 6,000 family lawyers in the state bar, we surveyed them, about 1,200 replied. 70% said they had advocated for 50-50 for their clients. 72% said that they had to go back for modifications of orders, not every order by any means, but they had to go back. It was a very frequent experience that they had to go back to court and modify a 50-50 agreement because it just wasn't working. That's additional litigation that really kind of goes under the radar here. Very much appreciate y'all's attention. We visited individually with all of y'all during the session, and we so much appreciate your service to Texas.
Thank you.